All right, good evening, everyone, and welcome to our edition here of the Meet the Paralegal Bencher candidate series here on Justice and Pieces. Again, I would start, hopefully I remember it every time, to say that the views are of the candidates alone there and don't reflect me, any of the educational institutions or anything that I'm affiliated with. But really happy here today. We have Jeffrey Smith joining us. And Jeffrey, maybe you can start by telling us a bit about yourself and your career there as a paralegal.
Sure. Thanks for having me. So a little bit about me. My main background is in was in security and investigations before I got into being a paralegal, as is pretty common in this field. I was licensed to 2019, which is fairly recent. Since then, however, I began working with Matthew Olson, who I'm also going to be running with. He is the owner of Olson Craig Legal Services. Our main area of focus is human rights law, democracy, freedom, and all that lovely good stuff. I have a certificate in provincial offenses from Osgoode Hall Law School, regulatory compliance from Pennsylvania State School of Law, and I can't find it, but I do have a certificate in contract law and one in justice from Harvard University. So that's a little bit about me and my legal-oriented background.
So I guess then the next question there is why are you running? And you mentioned Matthew there, and I understand that there's some paralegal candidates you're running kind of affiliated with. Maybe you can tell me sort of how that works and more about why you're running yourself.
Sure. So why I'm running? I'm running because I noticed there's a very significant lack of good paralegal candidates who, in my opinion, care about the profession and want to seek legitimate change for the better. When I saw who else was running, this was before, of course, we had to do candidacy forms. When I saw the people who'd announced, I was disappointed, to say the least, with what was, and I was concerned that these would be the people who would be governing our profession for the next 4 years. And I had no choice but to put my hat in the ring and to run for it because I did not want these people to be in control of our profession for another 4 years. I think the last series of years have been abysmal, to say the least, for our profession, and I think we could do much better, and we need to do much better, and that's why I decided to run this year. Now, to your second question, before you start asking about the our group, yeah, so it's me, Matthew Olson, Tony Caruso, and Sean O'Connor. We like to call ourselves sort of the Common Sense Coalition. We are not a slate in the sense that you'd understand, and that there's no whip. All we're doing is pooling resources so we can run together because we have similar ideas, similar goals, and we want similar things from the Law Society. It's not a slate in the sense, again, that we have a whipper that we're going to be, controlling who votes for what if more than one person gets in. Everything's going to be conscious vote. All we're doing is pooling our resources because the competition has a much larger swath of people running than we do. And so we need to pool together in order to make sure that paralegals who, in my opinion, care about the profession get in. And this is just my opinion, but the paralegals who don't care about the profession don't get in, just so to put it gently.
So I guess maybe you can tell us a bit about some of those shared ideals. Now I know I had the Good Governance Coalition yesterday, and they kind of have something that they're saying is similar, right? In terms of they have shared principles that they subscribe to. So maybe you can share some of those, and then afterwards we can look specifically at your campaign and what you want to focus on.
Sure. So the things that we share in common is we want immigration law. Our opinion is that immigration law is actually already allowed by the bylaws and the Law Society Act. The Immigration Act and the case law, I think, is very persuasive. And I'm of the opinion that immigration law is actually permitted. And the reason why the Law Society is saying it's not is to further the interests of lawyers, and it's not upholding its mandate under the Law Society Act in terms of protecting the public. So that's one thing that we share in common. The next thing we share in common is we think that paralegals should have right to conduct appeals on matters that originated from within a paralegal scope of practice. Arguing a case before an adjudicator, arguing a case before a judge. I mean, we appear before judges. We do provincial offenses court appeals. We go to criminal court. We already have that skill set within us. The only thing that would need to be updated in terms of a skill set would be what forms to use. And I don't think that's a highly complicated or highly contentious issue. You can learn what a back page is pretty quickly. You can learn what the different notices and what's available in Superior Court pretty quickly. You can learn that just from reading case law. And most paralegals that I know of, they already know how to do it, but they just don't do it because Law Society won't let us. And I think it is a disservice to our clients in the fact that we can't appeal their matters when we get bad decisions from adjudicators. And I think there's a certain degree of lawyer self-interest involved in that, because if paralegals can appeal cases, that means lawyers essentially can argue those cases against us. So it increases everything for everyone in the profession, and it protects the public by ensuring that good judicial decisions are made and justice is not denied to somebody on the basis of whether or not they can afford a lawyer. The third issue is going to be family law. My position, and this isn't shared by everybody, but my position on the family law is that the license that we got is an abysmal failure. And I think it will hurt the profession. I think it will hurt the public. And I think it needs to be completely scrapped. And we need to just go with what Justice Boncalo said, which was essentially a full scope of family law services for paralegals. I know there's concerns about competency and this, that, and the other, and dual licensing and all that. We are not for dual licensing. We are all mutually against dual licensing. A P1 is good enough. It's good enough. You don't need a license for every tribunal you appear before. And we shouldn't start going down that road. That path is a dangerous path, and it is a, in my opinion, overtly onus path. And the last issue, the two that we think we share in common, is going to be a special prosecutorial code of conduct. So when you go to court, you deal with a prosecutor. Prosecutors interact with the public, general public, probably more often than any other single member of the profession. And they hold a significant amount of power, sway, influence over the general public. And the consequences of what they do and what they don't do is extraordinarily severe to people. It can cost them their livelihoods, their driver's licenses, their freedoms. It has very significant implications, and they have a special role in the administration of justice. And I think it's about time the Law Society fully acknowledges that special role by the introduction of a special code of conduct and a special body to investigate and prosecute issues of prosecutorial misconduct. And I think that's what we have in common. That would be a full answer to your question there.
And I guess on that, is there anything sort of specific to yourself in terms of your platform? I mean, maybe obviously sharing some of those ideals, but anything maybe that you can add to what you've just said there that you stand for yourself?
Sure. So for me, I do stand for all of them, but my big focus, my big personal focus is going to be on the prosecutorial code of conduct issue and allowing paralegals to have a full scope of appeals on matters that originated within our scope. Those are my two big ones. My third one is going to be no more dual licensing. I don't think that needs to be allowed. Quite frankly, I think we need to scrap that idea and just start all over.
All right, so let's start, I guess, with immigration. I believe yourself and Tony and it's Kashif, if I'm not mistaken.
Kashif Haider, yes.
Yeah. Are we don't necessarily need to go into sort of where the case is legally. I understand it's still before the courts, but I mean, I see it kind of, there's two issues, right? One is obviously legally, as you're saying, your position, which the courts will decide, is whether or not you already can. But I mean, the broader question should be, even if the courts say otherwise, is should paralegals be able to provide full scope immigration services? I mean, is that in the public interest? If we want to look at that in the law study mandate. So maybe you could tell us, without going to kind of going into the legal analysis, because that's not necessarily here or there, but why it isn't, right? I mean, from the Law Society's position, why it should be, I mean, regardless of legally where it may change, as a result of a superior court or court of appeal or Supreme Court decision down the road.
Yeah, I mean, it's very hard to divorce the two ideas, right, between the legal analysis and whether or not we should. I mean, on one hand, if the law says we should, well, that's democracy in action, in my opinion, right? People, they vote in elected officials. Elected officials vote on laws and rules, and these laws and rules become what governs our society. And so I can't divorce the legal analysis there, because to me, it's a fundamental aspect of democracy that federal parliament said paralegals can provide these immigration services. And these are the elected officials. The Law Society is not elected. The Law Society is a regulatory body that exists in the province of Ontario. And so when we say paralegals can't do immigration because the Law Society says no and the federal law says we can, I look at that and I say, this is the Law Society not caring about democracy, not caring about fundamental principles that have ran our society for 1,000 some odd years. I mean, more than 1,000 years, really. Maybe go back to ancient Rome. But the fundamental doctrine here is that should we be allowing a regulatory body to usurp the fundamental aspects of our democracy? And we talk about the mandate. Well, the Law Society has many mandates. One of the mandates is to uphold the rule of law. And I think the Law Society is acting contrary to that rule of law. And that's a very big problem to me. I recently just had a chance to send an email off to the Law Society demanding for an inquiry and several issues pertaining to immigration. The Law Society is posting saying that paralegals don't actually have a full scope. And I have yet to receive a reply, but I'm giving them 48 hours to do so, and I will take the matter to Parliament and the legislature myself and go through that way. So when in terms of protecting the public, I mean, that raises two other questions. One, is a person who is not yet a Canadian citizen a member of the public? And two, does it actually protect the public? I think the answer to the first question is very important because that determines whether or not the law side even has any jurisdiction or any say whatsoever. And again, I can't divorce from the legal analysis here. If we accept the fact that immigrants are Canadian citizens, and I do, I fully believe that any person who is on Canadian soil, there was an old expression from the 1700s that the British used to use for slavery when slaves would come over to Britain for freedom. It was the air of England is so free that any man who breathes it can no longer be a slave. And I think the same concept has to be held in Canada. So absolutely, I think immigrants, whether they are citizens or not, deserve every protection under law available to them, and that includes representation in court. The right to representation is a fundamental charter right, and we need to provide that to people. And I think the Law Society is making that extraordinarily challenging by telling paralegals that we can't do it when I think we very much can. And the second part is how does that protect the public? Well, it's been noted multiple times going all the way back to 2010. The issue was never with paralegals and lawyers. The issue was with immigration consultants. That was the issue, and that was the issue that Parliament noted. In fact, it was called the Cracking Down on Crooked Consultants Act originally. So when we talk about protecting the public, who are they protecting the public from? From licensed, insured, competent legal advocates who on a regular basis handle proceedings far more complicated than filling out applications and waivers. And we still do applications in other forms of court. For example, anything for social benefits tribunal, landlord tenant. We do applications anyways. It's well within our scope. So why is an application for an immigration issue not accepted? I can't wrap my head around that, and I can't wrap my head around how not allowing us to represent vulnerable people and immigrants are vulnerable, right? They come over or they're trying to come over. Maybe they could be escaping a bad situation. People generally speaking don't leave their country on good terms. So these people desperately need our help. And when it comes to protecting the public, as somebody who's licensed, insured, and competent is the key issue. So I think the Law Society has regulation in terms of whether or not we are competent, because that is necessary to protect the public. Obviously, an incompetent paralegal does not protect the public. But the vast majority of our profession are competent individuals, and they would not take on matters if they were not competent to do so. So I think there's a sufficient protection from any sort of issues in terms of the competency regulation. And I think that the public, including the international public, but the domestic public as well, is much better served by having paralegals to assist these people on simple applications. Because the way I look at it, the proceeding at the IRB is much more complicated than an application. And if an application does have to go to the IRB, you want that application done properly to ensure the best chance of success at the IRB. And how do you do that? Well, you do that by having a trained legal advocate do the application first, who knows where it's going to end up. So you're no longer trying to fix a mess, because anyone in law who's done law has had clients, and we've taken a case on halfway through, and we find out that there has been a whole bag of messes that we now have to deal with. But if we can take a matter from the start, from the application stage, we can cut down on that significantly. And that is why I think immigration needs to be opened up to the public, because I don't see anyone's interest being served by preventing paralegals from doing immigration law other than lawyers. And the Law Society's mandate is not what's best for lawyers, it's what's best for the public. And that's my position on immigration.
Yes, I mean, on that point, I guess that's the sort of inherent tension, right, with the Law Society. I mean, as much as we're talking, it's the Law Society's mandate should be in the public interest. I mean, look at the breakdown. There's 5 paralegal bencher, I believe it's 8 lay benchers, and then 40 lawyer benchers, right? So, I mean, within, let's say, we already have, the framework that you're going through the courts, which is one avenue, but now that you're running for bencher, I mean, with that sort of breakdown, let's say, even if the 4 of you, were to all get elected, I mean, there's still kind of that, how would you see advocating there with the rest of convocation in terms of getting them to recognize that, hey, and certainly we'll have the same discussion with some of the other issues you raised about family law and prosecutorial conduct and so forth. But how do we get the majority there of benchers to pass this within the Law Society's framework of convocation?
So we don't necessarily need to get it passed by way of a motion. What we need to do is we need to get the Law Society to recognize the interpretation of the bylaws and the rules, and to recognize the fact that we already do this, because law and legal interpretation is all about consistency. If we recognize that paralegals consistently do applications at other venues, there can be no justification for the restriction on paralegals doing it in immigration. And when it comes time to, how do we convince everyone else to vote on this? We have to remember that it's true. There's issues under, I think, in my opinion, under the Competition Act with how the Law Society is laid out. I know the Competition Board warned people and warned the public about what happened if paralegals were licensed by the Law Society, because you can't have McDonald's regulating a Burger King. So in terms of getting it voted, it needs to be structured in such a way that it's not opening up a new scope, it's just recognizing an already existing scope. And I think that will have a much better chance of success at within the Law Society organization itself than trying to frame it as a new scope. And just so we're clear for the record, I'm no longer part of that court application, just because I didn't want there to be any risk of conflict or anything of that nature. So I am no longer part of any court action against the Law Society in relation to immigration.
Okay, so again, so I mean that sort of raises then the point, as we've been discussing, right? Is this structure? I mean, I heard yesterday electoral reform, or I mean, I don't know if you have a position on should there be a change in terms of the distribution. I mean, I'm not sure off the top of my head what the number of the new licensees. I know there was like a post from the Law Society, welcome to the new licensees of 2022, but how many are newly licensed paralegals? How many are newly licensed lawyers? Because I mean, is it still this 8-to-1 ratio that it may have been, back 15 years ago, where that may have been the justification at the time? I don't know. I'm just sort of guessing here of why the seats were distributed accordingly.
Yeah, so I don't have the exact numbers before me, but it's hard to imagine that there are more lawyers graduating than paralegals, right? And we have a few law schools graduating a handful of students, and yet we have virtually every college graduating dozens upon dozens of students, and you factor in with how many colleges there are, and then how many people write the license exam. I think that representation does have to be equal, and I think that's supported in law. I do think the Competition Act speaks to that. And so when it comes to representation, we're not asking for anything more than just what the law says needs to occur. And the Law Society has a duty to encourage and foster respect for the law. Well, if the law is saying that we need equal representation in terms of per capita representation, then the Law Society needs to amend and needs to address it. Otherwise, it's going to find itself in violation of the Competition Act, in my opinion. But how do we get the Law Society to agree to that without a court action? Excuse me. Well, most lawyers study law, study charter, study constitution, and they understand the importance of democracy. And when we start talking about upholding democracy, we can frame it in such a way that it's no longer we need more paralegal votes. It's we need equal representation, because that is what is demanded of a democracy. So if we want our law society and by proxy our society to be a democracy, we need to conduct ourselves as a democracy. We need proportional voting. Personally, I think the role of bencher should be changed so it's advisory in nature, and that every issue can be voted on through the LSO portal. We vote for benchers through the portal. Why can't we vote on anything else through the portal? No one has given me a clear answer as to why we can't just do that. And I think that would be a very effective means.
Like on important issues like a referendum, let's say, of sorts, of what do the licensees feel, or or even just like a survey of sorts to say, well, where do we kind of stand on some of these larger issues, whether it's expansion of scope, whether it's confirmation, as you put it, of existing scope that you believe is already in place, right? Is that kind of what you're getting at?
Exactly. I see no reason why we couldn't say, take the immigration question, put it to the profession, and let everyone vote through the portal. It's proportional, it's direct, and we can have our benchers, say their piece, like almost like you do in Parliament, right? You have a representative who says his piece, but instead of having a representative vote for you, you get to vote directly. You just hear what your representative has to say, and I think that could work with an online voting model, which we're doing for the bencher election anyway. So if it's not good, so if it's good enough for the bencher election, I don't see why it wouldn't be good enough for anything else.
Now, in the same vein, we've talked. You've addressed some of the other areas. Let's say let's go to family law, right? Because of what ended up happening when it ended up passing. So I guess to reiterate, you were saying that, or maybe it's the position there of your coalition, that um, you don't need an additional license, right? So what I mean in terms of, now I'm pretty sure no paralegal college has, like a family law course, or maybe there's an elective or something. But what would you propose then in terms of, if anything, of, let's say, you have your P1, what do you licensees or paralegal licensees need in terms of having that competence without needing to get, a dual license as they've laid out in the framework from last year?
Sure. So there's two aspects to that. The first aspect I'm going to address is I've appeared at boards and tribunals that I was never taught about in college, and I won. I have done cases that involve legal issues I was never taught in school, and I won. I have done cases that involved, very complex issues. I have did my internship with a lawyer, for example, and I worked on things that were within scope while working under a lawyer. But I came to realize something is that the key aspect, the thing that makes competence in advocacy, is three things. It's knowing your client's case, knowing the other side's case, and doing your legal research. So when we talk about what education does somebody need to be competent in family law, no education system can cover every single issue that arises, period. No education system could ever do that, not in a million years. You could spend 30 years at university, 30 years in college. You would never cover every single potential issue that could possibly arise. And even if you could, well, guess what? You started 30 years ago. The law is going to change in that 30 years anyways, making everything you learned in the first year completely useless. So as long as you maintain those three things, which are necessary competencies, no matter what scope you're practicing, what court you're in, what area you're in, it doesn't matter. You have to do three things to be a competent legal advocate. Know your case, know the other side's case, and do your legal research. So as long as people keep doing those three things, which most of my colleagues do, I see no reason for further education, no reason for further licensing, and no reason for any other issue that can possibly come arise. And we talk about, the risk of, well, what if a paralegal doesn't do that? Well, the rule is already that you cannot take a matter that you're not competent to take on. The rule is already you have to do legal research. So if somebody's not already doing that, they shouldn't be having a license to begin with. So I don't know why we need a second license when what you need to do in order to be competent for your first license is good enough for family law, in my opinion. Do I know family law? No, I don't. Do I plan to practice family law? Yeah, I do. But I plan to do my three key competencies. Know my client's case, know the other side's case, and do my legal research. So I'm not represent them in a fashion that's not competent. The rule is you can take on a matter if you don't know anything about it, as long as you can become competent without undue expense or undue delay to the client. And I see no reason why me as a sitting paralegal could not take on a family law matter without undue delay or undue expense to my client and be competent in advocating for that. I advocated my own family law case. My kid is in the next room with me. I have primary residency of him and everything. So I didn't even have paralegal school back then. I was just a guy off the street. So if I can do that competently as just a guy off the street, a licensed, trained, competent advocate who's insured, who already knows how to do the three basic competencies for any legal case, no matter where you are, no matter what case you're doing, absolutely do not need a second license. And absolutely, we do not need these ridiculous restrictions on scope. And I'm sorry, but the restrictions on scope as they're framed, who's being served by that restriction? I can't even imagine a person that or a case that could possibly fit within what we're allowed to represent. I can't imagine that even occurring. The closest I can come up with is an uncontested divorce. Well, why do I need to take a year or so, hundreds of hours, I forget the exact amount, of free work for a lawyer to take what is essentially nothing more than an uncontested divorce? It's mind-boggling. And I think about all the paralegals who want to do family law, and I think about how many man hours and how many labor hours paralegals are going to give to lawyers for free, and then come out of it without being any sort of competition for them, without being any sort of advocate for the public, and without any sort of public interest in place. To me, that says lawyers' interest being served and not the public's.
So in terms of, I guess, the counter argument tends to be, well, lawyers went to university and then they went to law school and this, but as you raise, myself as a lawyer, I can decide, hey, I'm tired kind of teaching. I want to just do family law, which I've never done. I may have had a course 10, 15 years ago, but to the same point, right, is that there's nothing otherwise, other than our existing rules that would stop me from doing that. And I guess, what's good for the goose is good for the gander, as you're saying, is, well, why not for paralegals, right? I mean, is this a question of, no, the law study says, hey, and as of last week, they had a report there, the paralegal colleges, additional hours of internships, things like that. But I mean, are you saying that there can be, whether it's on your own, whether it's through CPD, whether it's through getting mentorship from lawyers and family law, I mean, is that something that can be filled in? No different than for a lawyer who has scope in whatever areas, that if they go from one firm to another and they want to pick up a new practice area, they learn through mentorship, right? And is that kind of the same way it should be for paralegals, with the difference being the different education that you got years ago in some cases, right? I mean, you could be licensed till 10, 15 years ago. Should that be the barometer of where you are, in 2023 to what you can practice?
Yeah, again, I see no reason why it couldn't be done exactly similar to what you suggest. A lawyer moving from one practice area to another doesn't need a second license. You're expected to do your big three, right? Know your case, know your client, know the other side's case, and do your legal research. Paralegals are the exact same thing. I see no reason why the same protections in place are insufficient for family law, and I see no reason why we couldn't just do the exact same thing, because not all lawyers, as you know, actually take family law courses, but they're permitted to practice in family law. So why would a paralegal have to if a lawyer doesn't have to? I mean, you could make the argument about, well, wills and estates. Well, again, not all lawyers take wills and estates, but they can still practice it. Why can't a paralegal? You know your cases, you know your competencies, and you proceed that way. So I think there are sufficient measures in place to protect the public, and I think the scope does need to be completely opened up to paralegals, because the restrictions are unreasonable. It doesn't benefit the public. It doesn't protect the public. Even if a paralegal goes through all those hoops to get it, it doesn't serve any public interest, doesn't serve any public good. What it does is it shelters the sitting lawyers from competition, and it provides significant amounts of what I'm just going to call educated slavery for lawyers. You see, law students on their internships are paid, paralegals are not. So when a paralegal wants to wants to get that FLSP license, they go and they do unpaid work for a lawyer. Would I have the same issue with it if it was a paid placement? I still would, actually, because I don't think we need to actually go through it. I think any competent paralegal is going to know their case, know the other side's case, and do their legal research and conduct themselves competently. And if you're not doing those three things on any cases you take, it doesn't matter if it's small claims. It doesn't matter if it's a murder trial. It doesn't matter if it's a small case or a serious case. All that matters is that you do those three things. And as long as you do those three things, you are maintaining the standard of a competent licensee. And you can do that in any case and in any scope.
And I think the third area there was divisional court appeals within existing areas that are within your scope. Maybe you can expand more on why, again, that should be expanded to allow paralegals representation there.
Yeah. So my position, my personal position anyways, is that we should have no restrictions on scope, and we should be able to practice just as any other lawyer can. But that's not going to be an easy sell. An easier sell, I think, is going to be to allow appeals on matters that originated within a paralegal scope. And I'm going to start with the public interest argument here. So when you do an appeal, as you know, and as everyone else knows, the basis for an appeal is errors of law, the standard of which is correctness, and errors of fact, the standard of which is reasonableness. And then we can get into deference and this, that, and the other stuff. But that's a basic summary of what an appeal is, right? But if your case is not conducted properly, that means that you did not lead with your best foot forward, or as the Superior Court of Justice often says, play trumps or risk losing. So when we talk about appealing a matter from within a paralegal scope, if I take on, let's say, an LTB case, right? It goes through the hearing, I conduct it competently, I recognize all the issues, it goes, I can't appeal it to divisional court. Client comes to you and says, hey, appeal this for me. Who's going to know the case better? Me, who ran the actual hearing and ran the actual trials and did all the prep work, or you, some guy who just gets this big file plumped on your desk? I think the public interest is better served by allowing me to appeal it at divisional court. So that's a good public interest argument, in my opinion, right? And let's talk costs. Why did the person come see me first and not you? Well, sorry, I'm not singling you out, John Paul. I'm just using you as an example. So why did the person come see me and not you? Well, they came to see me because I am a cheaper alternative to you, and I can perform my services competently. I can argue the correct law at the LTB. Well, if I'm making an appeal on an error of law, that means I must already know the correct law. So why can't I argue correct law at divisional court just the same as I argue whether or not the law is correct at the LTB? Law is law. If I'm going to argue law in one venue, it doesn't change how I'd argue it in another venue. Law is law. And when it comes to, well, what about facts? Are there misapprehension of evidence? This, that, and the other? Well, guess what? Paralegals, we argue mistakes of fact in POA appeals. And that's something we're already doing. So what's the difference between doing a POA appeal and an LTB appeal? In my opinion, not a whole lot. So how does it protect the public by keeping paralegals out of appealing matters that originated within our scope? I don't think it does. I think it all comes back to the big three issues: know your case, know the other side's case, and do your legal research. And if you're competent in the originating matter, you're going to have a better time appealing it at divisional court and being successful than somebody who did not take carriage of the matter from day one. And even if you fudged up a little bit when you took on the case at the bottom part, well, guess what? The person who's going to be in a better position to know where they fudged up and to know how to fix that is still going to be the person with whom it originated and taking it to divisional court. So the client's interest and the public's interest are best served in either event. Now, I'm not suggesting you should fudge up. Of course, be competent in your cases. But no matter what, if you did a good job, you're in a great position to appeal it. If you did a relatively poor job, you're still in a better position to appeal it than somebody who has no knowledge of the case and no knowledge of the background. And I don't know. I think of how much hours you'd have to go into in order to make yourself competent on a landlord tenant board case, even a simple one, and then appeal it. You have to catch up on everything. You're looking at probably 8 to 12 hours of work to do a good, competent, thorough job on making sure the appeal is perfected. At least 8 to 12. And at $400 an hour, we're talking $4,800. Well, that's more than I would charge for the entire LTB hearing, including the divisional court appeal as a paralegal. So again, just to get you caught up costs you more than it would cost me, who had carriage of the file from day one, to appeal it. So it's not serving the public, it's making them dole out a metric ton of cash for something that they really shouldn't be doling anything out, because there's no added value in having a lawyer take on a file to do an appeal where the matter was handled from within a paralegal scope. And the second thing, self-interest for lawyers. If I, as a paralegal, get to appeal, let's say I'm representing a tenant, you're representing a landlord. Okay, great, my tenant gets evicted. I appeal it, it goes to divisional court. Well, if I'm off the divisional court, my tenant's not going to appeal at divisional court. So that's one less proceeding that you can do your business with. So there's a very good interest model in having lawyers from their own interest allow us to do these appeals, and that is that they can argue twice as many cases. But the counter argument to that then comes to, well, these matters are going to be appealed and we're just going to milk clients. That's not what I'm saying at all. I'm saying that people who have legitimate appeals, because again, you shall not take on a matter that is frivolous or vexatious or an abusive process. So if your appeal is legitimate and I'm taking it on, great. No licensee will ever take on an illegitimate appeal. So that counter argument to is just going to create more cases, I think, is moot, because nobody will take on an illegitimate appeal. And if you are, you shouldn't be licensed because you're not following your rules of conduct.
Yeah, I guess it does. Obviously, regardless of the area. In terms of if there's a potential ineffective assistance of counsel, whether it's a lawyer, whether it's a paralegal. Those are the cases where you should, within even in our rules, right, that even if another paralegal was then given the opportunity to take your matter and then do the appeal, right? The only option they would have now is to go to a lawyer, or if they can't afford one, as you're saying, then they would have to sort of self-represent, right? Because whether it's you yourself or whoever has done the initial work can't do the appeal. But of course, it doesn't preclude the possibility that if the scope was expanded, you could go to a different paralegal who could then, again, as you're suggesting, at a lower rate than whatever it may be for the lawyer, that again, if there was concern about if something was fudged up, then you don't preclude it's obviously difficult to argue, hey, I screwed up, and not in the client's interest, whereas someone else could raise that resolutely and zealously, a paralegal or a lawyer, so be it.
Yeah, that's why I think it should be opened up to either lawyers or paralegals. And as long as it originates, it doesn't have to originate with me. It could originate with me, and then it goes over, and let's say another paralegal, let's say who knows a paralegal, Mike Redden from Good Governance. Okay, let's say somebody goes to Mike Redden from Good Governance and says, hey, Mike, you're a good paralegal, you're a great paralegal, and I think he is a good paralegal, by the way. Jeff made a mistake on my case, or I think maybe he made a mistake on my case. Do the appeal for me, because I don't trust him anymore. I don't trust, even if he didn't make a mistake, the board ruled against him, so I don't trust him because the board ruled against him. I've had clients lose trust and faith in me because a board had ruled against me on a motion where they were wrong, in my opinion. And it happens. You can lay out the law correctly and still get ruled against. And it happens all the time at tribunals. So I think the test should only be whether or not the matter has originated within a paralegal scope, and not whether or not that paralegal has taken original carriage of the matter.
Now, I guess again, lumping all of what we've just been talking about throughout here, again, I hear in the public interest, and then is it, does this have to kind of go through, running for bench or being elected and going that route? Some would say, well, no, this is more about advocacy for paralegals, collectively, like, something like the Ontario Paralegal Association, or I know any other group that should be coming to the table, regardless of your opinion on whichever advocacy group, and meeting with, whether it's the lawyer benchers, whether it's the paralegal benchers, of, here's the interests of paralegals that we feel we want this, and this. Is that the avenue, is that an alternative avenue for paralegals to go through? Or, are you saying, well, hey, the last set of benchers didn't, in your opinion, right, didn't get these sort of things done. So let's try to run and get elected and see what we can do, right? Is there alternative options like that? Of course, we also know the court option, right? But can there be advocacy through groups to kind of go and push this, or is that not really working as well?
So I'm going to have a hard time answering that question because I'm actually the chair of the Law Society and Government Relations Committee with the Ontario Paralegal Association. And in case anyone who hears that is concerned about me running for bencher, if I get elected bencher, I'm going to resign that position. So there's not going to be any conflict. Absolutely, advocacy through secondhand groups is 100% necessary. And I think even if paralegal benchers push it through the best we possibly can, I still think that advocacy is necessary. And I think intervention from the government is also going to be necessary to get this done fully, thoroughly, and properly. I've seen how the law societies handle things since paralegal regulation, and I am not too overly impressed with with how it's conducted itself. And I think there's been a lot of self-service. But I do think that once the lawyer block gets on board and realizes that they can make a significant profit off that as well, it will serve their best interest to open that up to us. And I think we can pass it through that way. And you mentioned, a person's options at appeal is either hire a lawyer or self-represent. Well, there's a third option. You become homeless. You go to jail. You have an order that you can't pay, and you wind up losing everything you own. That's the third option. And I think people shouldn't be forced to choose between a lawyer and the streets. I think that's an abysmal thing that the Law Society is doing by forcing people to make that choice, and I think that needs to stop.
Now, I guess within that framework, you're mentioning the different groups. I'll leave the coalitions there that are running for the paralegal benchers, but there's two main groups for the lawyers, right? Like from the Full Stop and the Good Governance Coalition, and it's very possible you could have convocation consisting of like 18 and 18, and the balance of power could hold within the lay benchers and the paralegal benchers, right? As much as they may not necessarily vote in blocks, it may be something that as a result of the breakdown of who gets elected, that there can be kind of this split, right? Obviously there's a possibility that one entire slate, whichever one, could be completely elected, and even if they they may not necessarily vote together, they have all of these shared principles and values on both sides. That how do you sort of see if envision a scenario where there are either one or both groups kind of split, holding a lot of these seats, and then yourself maybe either on your own or with Tony or Matthew or whoever, kind of working together at convocation to get some of these things going through if elected?
Sure. I think Sun Tzu said it best. He said it's a bad plan that cannot be changed. And Miyamoto Musashi said it, in contests of strategy, it is best not to be led about by the enemy. Those two concepts are very important to answer your question. If it is split and it's no longer a block that you're voting with, and now you have the ability to convince individual actors to vote in a manner that you think is best for the public interest, no one's going to vote in a manner that they think is against whatever interest they represent. Now, whether it's a self-interest whether it's a public interest, whether it's public interest but grossly misguided, for example. Public interest, but they want to vote in a manner that's misguided based upon the facts. That's easier to change because you can always tell somebody, you can always show somebody, you can bring stats and arguments, and you can convince somebody who's open-minded if their vote is based upon the facts and it's not motivated by self-interest. Somebody who's motivated by self-interest can only be swayed by appealing to their own self-interest. It's not something I like doing because I think it shows a lack of logic. But if somebody's motivated by their self-interest, when we start talking about these things, anything can be framed in a way that benefits whoever it is. Because there's always benefits to expanding scope. Because once you expand scope, you expand services and you expand customer bases, you expand everything that goes along with it. And that expansion is going to be linearly with whatever the profession is. So there's 15,000 paralegals now who can do divisional court appeals. Let's just say, just as an example, 15,000 paralegals can do divisional court appeals. Well, great. Guess what? That's 15,000 appeals going through per paralegal, implying you get one a year, which I think is a low estimate, but let's say you get one a year. That's 15,000 more cases out there for the self-interested lawyer to take. And on that basis, that's better than limiting the amount of appeals before the court. Because you want to, if you're motivated by self-interest, you want to expand the amount of court action that takes place. You don't want to limit it. You want to expand it. You want lawsuits everywhere. You want appeals everywhere. You want all that business for you to take in. And well, guess what? By expanding scope to paralegals, you're going to get that. So not only are those people who only care about themselves being served, the people who care about the public, well, the public's being served because now it's no longer pay a lawyer or live on the streets. Now it's I can pay a paralegal and stay living where I am. So the public self-interest is served, and the self-interested lawyer group. I'm not saying any specific lawyer group is motivated solely by their self-interest or any specific person is, but if you have that self-interested person, their interests are met. And I think that is the better avenue to convince them. It's good for the public, it's good for the lawyers, it's good for every single person involved. There is no drawback to that issue other than you might have some people taking on matters they're not competent for, but that can happen in any scope and in any venue. And there are rules, there are measures, and paralegals are insured. So if you do take on a matter that you're not competent to do and you mess it up, you have insurance. The member of that public is protected by the fact that you have that insurance and by the fact we have strong regulatory oversight to make sure that you're competent, and that if you're not competent, whoever was harmed by your non-competence gets compensated for it. That is important to me. Then that's already in place. Nothing new needs to be done about that. So it's all about we can make every person happy by expanding the scope. And that is why I think it's a good thing. And that is the thing I think is most likely to carry the most amount of success.
So in terms of, are you saying maybe in terms of the powers the Law Society has with the Law Society Tribunal, in terms of ensuring, obviously, if there were situations, again, it's not like it's only paralegals. Obviously, lawyers can be disciplined.
I can show you my tort law book. There's a whole section on professional negligence just about lawyers.
Right? Is it? Look, here's the options that let's say if it were to expand. One is there's the ability to have various groups, whether it's the Law Society directly or maybe like a family law association or an immigration association that can put on training that, again, we have your 12 hours that you have to follow. And if you are not competent, as you laid out, can you follow those three basic principles? Well, then we have the tools in place to, if there's a complaint, to discipline. Or is there anything more other than sort of that basic premise of ability to learn more, or you should have that within yourself? And if not, there can be opportunities for continued professional development. And if not, then we have tools, obviously, in terms of disciplinary action against paralegals and lawyers if they're not competent. Is it just as simple as that? If the scope were to be enhanced, to respond to the criticism that paralegals are not going to be competent, there's going to be all sorts of complaints, the public's interest is not served because a bunch of people are doing things that they don't know how to do. They only had a 2-week immigration course in 2013 that is not good enough to do these immigration refugee board matters. Is sort of what some of the things I hear are being said of why you shouldn't get A, B, and C.
There's lawyers out there who've had a 0-week immigration course doing immigration, right? The standard of a competent legal professional is a standard of a competent legal professional. Whether you're a lawyer, a paralegal, whether you've had 30 years of experience or 1 year of experience, the standard of competence is the exact same for every single professional. There's multitudes of case law on this. The standard is lower for a self-rep, obviously, but the standard of a competent legal professional, it doesn't matter if you're a paralegal or a lawyer, 30 years experience, 0 years experience. The same standard is there. So we talk about, well, you didn't have this course, you're taking on this matter. Yeah, but you've done your 3 core competencies. You know the fact scenario of your client's case. You can reasonably, infer what the other side's case is going to be, and you've done your legal research. And that is the standard of a competent professional. It doesn't matter if you're a lawyer with 30 years experience. It doesn't matter if you're a paralegal with 0 years experience. The only thing experience does is it shortens down the time you need to do your legal research, but it doesn't negate the amount of liability. It doesn't negate the test for negligence. And it doesn't negate the test for competence. It's the exact same test either way. Do your 3s, and as long as you do your 3 steps, you can be competent. And to any students out there who are watching, saying, thinking, well, education this, education that, you're at the easy part right now, okay? You have to learn a heck of a lot in this profession, and the learning curve is steep. When you first come out there, you're going to feel stupid. You're going to feel like you're incompetent. The issue is not a lack of competence, it's a lack of confidence. Do your 3 basics, and you will be competent in almost every case you take. I cannot fathom a case where, as long as you've done your 3 basics, you have not been a competent legal professional. That's, at the end of the day, that's just the rule. When it comes to your oration skills, people say it shouldn't matter, but it does matter, and that is a skill you will learn through experience. But the test of a competent legal professional is, your case, you can reasonably assume what the other side's case is going to be, and you've done your legal research. In terms of protecting the public, that's the same thing a lawyer does in any case they take on. That's the same thing a paralegal does in any case, the same thing that's taken on. A fresh graduate does the same thing. A 30-year veteran does the same thing. That's my position on that. I hope that answered your question.
Yeah, and I think the last thing there I don't want to forget is you mentioned personally to you about a prosecutorial code of conduct there. Maybe you can tell us a little bit more about that and why
Thank you.
That's part of before we run out of time here, why that's part of your platform if elected.
So I am all about protecting the public. Anyone who knows me knows I care deeply about protecting the public, and prosecutors interact with the public probably more than any other legal professional does, especially self-represented public, right? I mean, you go to traffic court, for example, prosecutors are talking to people. You go to criminal court, prosecutors. The stakes are absolutely extraordinarily high at all levels of court when we're prosecutors, take bear. And when we talk about a special code of conduct, they need a special code of conduct because they're supposed to represent the administration of justice and not the city that they're trying to get ticket revenue for, and not the penal system they're trying to get jail time for. They're supposed to represent the administration of justice, and they have an immense impact on the lives of a person. And just the mere fact that a prosecutor carries a lot of weight and a lot of credibility that should not be used to further or advance their case, and should certainly not be abused, right? There's well-established duties of a prosecutor. There's disclosure, for example, that, you search up case law, you'll find 100,000 cases on a prosecutor not giving you disclosure. But how many cases do you find where a prosecutor was disciplined for not providing disclosure? I can think of a handful. I can think of Krieger v. Alberta, and that's about it. And that's Alberta, that's not even Ontario. We look at, evidence being withheld, for example. And again, you look, it happens a lot in the case law. Just go to CanLII, disclosure issues, you can find a bunch, but you will never find that same prosecutor being extensively disciplined by the Law Society and losing their license. You will see misapprehensions of facts. You will see in my opinion, needless motions having to be raised by people to get disclosure. And I think the moment somebody has to make a motion to get disclosure, if that motion is successful, it means the prosecutor did not do their job. And it means that prosecutor needs to be held to account, not just in terms of costs to the person who has to bring that motion, but in terms of the fact they were not upholding their special duty and their special interest to the public. We look at, I focus on disclosure, but of course, there's countless other things where they can fight tooth and nail on unreasonable things. For example, just today, we had a case that's been going on for well over 2 years, was finally withdrawn today. Well, that client had to pay legal bills for 2 years only to have a matter withdrawn. That to me is unacceptable. And we shouldn't be allowing that to occur in our legal system. If a matter goes on for so long and then it's eventually withdrawn, well, that prosecutor needs to be held to account for not withdrawing at the earliest possible opportunity. The moment that file comes in on their desk, they are expected to review that and know whether or not they have a reasonable prospect of conviction. They are not supposed to be reviewing that the day of a trial to withdraw it. To me, that's not competent. If I wait until the day of a trial to review a client's folder, I'm not a competent legal professional. Same goes for a prosecutor. A prosecutor's duty is not to convict, but to ensure that justice is done. That's the same duty that I have. But yet they can wait until the day of trial to review a case, and it's perfectly fine, perfectly acceptable. They can fight a case, they can delay a case unreasonably. Nobody cares. I do that as a defense guy, I'd lose my license. So we absolutely need to deal with the issue of prosecutors acting that way, and we need to protect the public. And I think that a law society body to investigate complaints of non-disclosure could save a mountain of court time, because now you'd have an uninterested third party who would say, you know what, the rule on disclosure is this, you got to get it. You got to make your requests. I mean, POA court, for example, right? McNeil requests. The amount of times they say, well, just go file an O'Connor application. No, RV McNeil says you have a duty to make inquiries. You make the inquiries. How many prosecutors have I actually seen make the inquiries? Maybe 2 out of like 100 cases. So in my opinion, by not making the inquiries, they've also committed misconduct. We need to hold the members in the justice system accountable as much as we can. And the Law Society is supposed to regulate these prosecutors, and they've been failing to do so. And that's why I think a special code of conduct to regulate them, to set out clearly, explicitly, and without question what they have to do and what they don't have to do, and what the consequences are for not doing those things, is absolutely crucial. The Attorney General's office probably won't like it because they'll likely get inundated with lawsuits over countless things, but that's what I call a growing pain. Once that happens, once they learn that it's no longer cost effective to play games with disclosure, to draw a matter on for 2 years just to withdraw it, it's going to stop. And when that stops, courts move quicker, they move faster, it's more expedient, and it saves court time. Clients, the public, get served better because my clients no longer have to pay me to fight, motions that should not have even need to be filed if a prosecutor is doing their job properly. And the general public doesn't get taken advantage of and played, because now the prosecutor is going to know, oh, Joe Blow over here with his speeding ticket, I can play games with him. He's not licensed. Well, guess what? Joe Blow can now call up the Law Society Special Prosecutor Bod and say, hey, this prosecutor's not giving me my disclosure. And right away we can have that. And we can have these investigative reports go to the court to assist the judge as well. So if it does come down to the fact we need a motion, this investigative report is neutral, it's a third party, and it goes before the court and it will assist the judge. And that's what the Law Society needs to be doing. We need to be protecting the public in that fashion. I just noticed we only have 3 minutes left. So I'm trying to shut my answer short.
Perfect there, Jeffrey. So thank you so much for joining and sharing your platform and know more about kind of, if elected, where the things you'd like to see done. I guess maybe to wrap up, kind of a twofold question here. One is, why should any of the paralegals that are listening vote for you, and perhaps extending to the others that you're running in affiliation with? And if you have any final words of advice for any of the students or anyone else listening. And once again, thanks so much for taking the time and joining us here today.
Oh, thank you. Let's be realistic. You have a choice to vote between people who actually care about the public and care about you as a profession, and you have a choice to vote between the Good Governance Coalition. I think actions speak louder than words. I think the last years of the incumbent ventures have shown to be absolutely miserable, and I think the people who join the group are probably going to be the same. If you want more of the same, vote for them. If you want a chance at expanding scope, if you want a chance at having a better functioning law society and a better functioning legal system in the province of Ontario, then absolutely give me a vote. Vote for Tony Caruso, Matthew Olson, Sean O'Connor, members of the Common Sense Coalition. Good governance has, in my opinion, not been very successful in their track record of the incumbent ventures, but obviously they have a bunch of new people, so I can't comment on that. And of course, that's what you got to choose from. So make your choice wisely, in my opinion. And to the students, remember the 3 core competencies I mentioned. Know your case, know the other side's case, do your legal research. You'll do fine. It's not competence, it's confidence, as long as you've done those 3 things. Thank you, Jump Off.
Thank you so much again, Jeffrey. And thanks for everyone for listening. And again, tomorrow, I guess perhaps I can continue some of these. If I don't know if I missed any questions, maybe somebody had, because I have Matthew on. So I think perfect follow-up here. We can discuss some of these a little bit more tomorrow. And thanks again for everyone for tuning in, and hope to see you again tomorrow. Take care, everyone.
Oh, thank you. Have yourself a wonderful day. Goodbye.